impeached. And Your Lordship, even as we speak about status quo, what is the status quo? The status quo is that the governor has been impeached. That decision has not been set aside.
Yes.
So, Your Lordship, we submit that the decision of the Senate can only be invalidated or otherwise through a substantive hearing of this petition.
Yes.
Not at interlocutory stage, Your Lordship. Your Lordship, I'll make reference to the case of, there's a civil application in paragraph 36 of my submissions, but I won't read into it, Your Lordship. I want to go to the next issue of whether the applicant has approached the court with clean hands, Your Lordship. Because clean hands is vital to the to conservatory orders, which is an equitable remedy, Your Lordship. Your Lordship, you were told of a court order. I believe we have since dispelled those rumors. There was no court order, Your Lordship.
Yes.
And so, Your Lordship, on this, David is sworn that there exists court orders, Your Lordship. It deceived this court. This limb alone is enough to demonstrate that the applicant has not approached the court with clean hands, Your Lordship. Your Lordship, I'll finalize with whether this court should set aside. Your Lordship, far from what you have been told, that the issue of misjoinder, Your Lordship, or non-joinder for that matter, Your Lordship, we have also spoken to the issue where our states that there were existing court orders, Your Lordship. But perhaps for context's sake, Your Lordship, I will refer you to a decision by Matatu Owners Association versus National Council of Administration of Justice and another. That is paragraph 43 of our submissions, which speaks to when a court can set aside ex parte orders issued, Your Lordship. And one of the grounds therein is misrepresentation of facts or non-disclosure of material facts, Your Lordship. Your Lordship, the wrongful joinder or non-joinder of the Senate is just one of the issues, Your Lordship. Your Lordship, you are told there is an existing court order. There is none. And secondly, Your Lordship, you've been told that they correctly sued the Speaker of the Senate. You've been given a plethora of authorities about that, Your Lordship. But Your Lordship, under Article 122(2)(a), the Speaker has no vote in matters before the House.
Yes.
Your Lordship, how then would you have a situation where you sue the Speaker, Your Lordship? In fact, if I've listened to my seniors, my colleagues, the entire time they've talked about the Senate, the decision of the Senate, the resolution of the Senate, Your Lordship. They have not spoken about the Speaker.
Yes.
I strongly believe, Your Lordship, and it is our submission, that the proper parties in this matter is the Senate, Your Lordship. The Senate undertakes this exercise. The Speaker is an ex-official member, Your Lordship. And finally, Your Lordship, I still make reference at paragraph 50 of our submissions that if the court finds that indeed it is the case, and I submit it is the case, then the court can actually discharge those orders, Your Lordship.
Yes.
And in any case, Your Lordship, just going back to the issue of the Senate, Your Lordship, if you look at the orders that were granted by this court, Your Lordship, and Your Lordship, perhaps allow me to just read the order.
Yes.
Your Lordship, order number 2 states that pending the inter parties hearing and determination of the application dated that a conservatory order be and is hereby issued staying the furtherance or implementation of the resolution of the Senate, Your Lordship. The Senate is not a party to these proceedings, Your Lordship. How can it be that parties benefit or seek to benefit from conservatory orders wherein those parties have not been sued, Your Lordship? I submit that cannot be the case, Your Lordship.
Yes.
And in any event, Your Lordship, as submitted in paragraph 54, order number 3, which was granted, restraining the Speaker from publishing or causing to be published in the Gazette notice, was overtaken by events, Your Lordship. They say that the Gazette notice was predetermined, Your Lordship. We have at length given explanations and reasons as to why that is not the position, Your Lordship.
In brief, why isn't that position?
Your Lordship, when the Senate undertakes its business in accordance with the order paper, there's the order for the day, Your Lordship. The order for the day was the impeachment, Your Lordship.
Yes.
And Your Lordship will notice at paragraph 46 of our replying affidavit, we have at length explained what happens when there is a division, Your Lordship. Division simply means voting, Your Lordship, in the House.
Yes.
When the division happens, Your Lordship, it allows the Senate or the House to continue with proceedings until that division is complete. And Your Lordship, in that regard, the proceedings of that day are still continuing until that vote on the division is taken, Your Lordship. This is in the Senate standing orders, Your Lordship. Order 34-6, Your Lordship.
Order?
34-6 of the Senate standing orders, Your Lordship. We have at length explained that from paragraph 46 all the way downwards, Your Lordship. And I believe that...
The petitioner's position...
Yes.
I've paused your time. The petitioner's position is that the Gazette notice shows that this was a predetermined process where the outcome was notified to the general public before the vote actually took place. Is that factually correct?
No, Your Lordship, that is not factually correct because of the explanation I have just given.
Part of the reason we open court, and you can see that I am logged in,
Yes.
is for the benefit of persons who are following this proceeding. So in as much as I've read your various responses,
Okay.
please articulate that
Okay.
so that they are able to understand.
Okay. So, Your Lordship, I have given Your Lordship the standing orders, the relevant standing order, which is 34-6.
Yes.
Now, Your Lordship, upon the close of submissions by the parties,
Yes.
the following events transpired, Your Lordship.
Upon the close of submissions
By the parties.
before the Senate.
Before the Senate, yes, Your Lordship. The following events transpired. I make reference to paragraph 47 of our response to the petition and the application.
Yes.
Your Lordship, 1, the Senate Majority Leader moved a motion
Yes.
for the impeachment, Your Lordship. Majority Leader moved a motion
Yes.
for the impeachment, Your Lordship.
Yes.
Secondly, Your Lordship, and just to summarize, also moved a motion pursuant to standing order number 111, sorry,
Yes.
that the debate for the proposed removal be limited, Your Lordship. These are from the standing orders, Your Lordship.
Yes.
And Your Lordship, once that was complete, a division was proposed, Your Lordship. All this happened in the day gazetted for the impeachment, Your Lordship. Now, Your Lordship, once the division was proposed, then under the standing orders, Your Lordship, division has to be complete. before the business of the day is concluded, Your Lordship. And that is exactly what happened.
Okay, your time is back.
Yes. So, Your Lordship, it is only after the division and the taking of the vote that the process was concluded, Your Lordship. And in any case, that is why the Gazette notice reads that date, because it is the date when the business was complete, Your Lordship. It does not spill over to the next day, Your Lordship.
Yes.
And so, Your Lordship, I think with that, and barring a clarification from the court, I would beg to rest my submission. On that, Your Lordship.
Still have quite a bit of time, 6 minutes, 42 seconds. Comfortable?
Yes, I'm comfortable, but I can donate to an interest.
Submissions.
Thank you, Your Lordship.
Mr. Lawi?
Thank you very much, my Lord. On the part of the first interested party,
Yes.
we have filed written submissions dated 2nd October 2024, alongside our list of authorities,
Yes.
also filed and dated on given date, my Lord. We wish to rely wholly on the contents of these submissions and the authorities placed before you, my Lord. My Lord, we will further wish to associate ourselves with the submissions of the petitioner, who has just highlighted them before I rose on my feet. Your Lordship, these submissions are in support of the petitioner's application dated 21st August 2024 and in opposition to the application by the respondent dated 3rd September 2024.
Yes.
Lord, in light of saving judicial time, I may not wish to regurgitate what has been said by my learned senior, Mr. Ngoya, and also my learned colleague, Mr. Mutuma.
Yes.
Your Lordship, the application by the petitioner was filed after the petitioner, Her Excellency Governor Ria Mwangaza, underwent an impeachment process, was marred with unconstitutionality, in bad faith, and tainted with procedural impropriety,
Yes.
as will be demonstrated at the full hearing of the instant petition, my Lord.
Yes.
My Lord, the application for the conservatory orders, my Lord, was summarized in the case of Wilson, Kaberi, and Kunja versus the Magistrates and Judges Vetting Board and another, that is Constitutional Petition number 154 of 2016 at the High Court in Nairobi. It is authority number 1 in our list of authorities.
Yes.
The principles have been well enlisted in this particular case, and I would just like to summarize that the applicant must demonstrate that they have a prima facie case with a likelihood of success unless the court grants the conservatory orders. There is a real danger that the applicant will suffer prejudice as a result of the violation or threatened violation, and further, if the conservatory orders are not granted, then the petition will be rendered nugatory. From the summary that I have just been able to lay down, the first interested party has laid down the issues for this court to warrant this court's determination in our written submissions. And my lord, the issues are 5 of them, and I will list them. Whether the applicant has established a prima facie case to warrant the issuance of the orders.
Mr. Lawe,
Yes.
I think the counsel for the petitioner canvassed those points.
Yes.
While there are different authorities,
Yes.
those speak on. The principles were long established.
Yes.
So maybe you can skip that to the end.
Yes, my lord, that forms the substratum of my submissions because these principles have been laid out, and I was actually intending to avoid regurgitating the points that have been already laid out. But perhaps, my lord, just to go into the issues without repeating the authorities because they are on record for the judge, for the court, to be able to decipher. My lord, as I delve into the first issue, and as was said by my learned colleague, Mr. Mutuma, on the issue of the prima facie case, my lord,
Yes.
it has been stated by the principal.
The challenge that the court has
Yes,
is those, you can go all the way back to the 1950s.
yes,
You can even go beyond it on what is prima facie case.
yes.
I'd be constrained to record something twice.
My lord, is the position of the court then that I just adopt my submissions because these issues and these principles are well laid out? Unless the court is inclined to make me just adopt my submissions, we will be guided by yourself.
I'd want to save the environment by conserving ink, so writing twice may not
Yes.
be the best way.
Yes.
What I'd wish you to highlight
Yes.
is more of the why.
Yes.
That the role of an interested party has been well defined
Yes.
all the way up to the Supreme Court. Why is the interested party saying that these conservatory orders should be confirmed and extended to judgment?
Yes.
That you could use your time on that, please.
Perhaps, my lord, just to give you, although this is not in my written submissions,
Yes.
we were constrained to only file written submissions. I didn't file a response. But perhaps just to come to bring to the court up to speed of the functions of the first interested party,
Yes.
they are laid out under Section 20.
Yes.
And part of the functions of the first interested party is to consider matters of common interest to the county governments.
Yes.
That is part of the mandate that has been bestowed upon the first interested party.
Yes.
And impeachment of county governors has been a matter of concern to the first interested party, specifically, my lord, with regards to the issue of the procedure and the process that was followed.
Yes.
My lord, the law that relates to removal of governors from office is laid down under Article 181
Yes.
and also under Section 33 of the County Governments Act, my lord.
Yes.
But my lord, I will wish to submit that part of the processes that have been adopted both by the assemblies and the senates have been through jurisprudence of these courts. So the first interested party takes a lot of interest with the impeachment process to be able to follow through, albeit in a very neutral process, my lord, but just to be able to see through
Yes.
that the procedures that have been laid out, the procedures with regards to fair hearing,
Yes.
fair administrative action, the rights of elected, specifically governors, to hold office under the provisions of Article 38 have been laid out, my lord. That is the specific interest that the first interested party has with regards to this particular process, my lord. Without, my lord, that was just a background. Without, my lord, going into the meat of whether a prima facie case has been laid out, my lord, allow me to skip into that so that I can just canvass the rest without necessarily regurgitating what my learned colleague,
Yes.
Mr. Mutuma, has said. What is the likelihood of the prejudice? That is my second point on my written submissions, which concerns itself with whether there is a likelihood of prejudice if the conservatory orders are not issued, my lord. The prejudice that the petitioner is likely to suffer, my lord, pursuant to this impeachment process,
Yes.
in the failure of the conservatory orders, my lord, there are processes that kick into place. The first process is that, in line with the assumption to office of the Governors Act, the deputy governor is then sworn in, my lord.
Yes.
What are the consequences of the deputy governor getting sworn into office, my lord? And the prejudice that the petitioner will suffer in the unlikely event of the court not granting these conservatory orders, my lord, automatically there will be a change in the whole executive of the county government, save from in the position of governor. The rest of the members automatically go with the outgoing governor, if so.
Yes.
This leads to a complete shift in the governance of the county, my lord. There is a likelihood of possible changes in policies. As my lord, you're aware, the governor, being the head of the county, is the #1 policy holder, my lord. So there is a likely change in policy. There is a likely change in some of the legislation that then operationalize the policies that have been put into place by the administration.
Yes.
My lord, there is a constituent that is not presently before you that may not have the audience. Those are the CECs, members of the County Executive Committee. The prejudice that they may suffer, my lord, once they go out by operation of law, what then happens to some of their obligations, my lord? Some of them may have running facilities. I don't speak for them, but that is the prejudice that they may be able to suffer, my lord, if these changes are likely to be occasioned, my lord.
Yes.
As I finalize on that point, there is no prejudice whatsoever, we submit, in issuance of the conservatory orders, pending the hearing and determination, and we will pray we have an expedited one, of the petition that has been filed before you, my lord.
Yes.
The next point, my lord, is whether the substratum of the petition will be rendered negatory without the conservatory orders being put into place, my lord.
Yes.
My lord, as I've stated earlier on, the substratum of this petition may be reduced into an academic exercise if the subject matter, that is the removal, is not preserved, pending the hearing and determination of the petition. And as my lord has been stated, there are already tribal issues that have been highlighted by my learned colleague, Mr. Mutuma. Tribal issues with regards to compliance with court orders, my lord.
Yes.
With regards to the fair hearing that was afforded to the governor in the Senate. With regards to a predated gazette notice, according to the petitioner.
Yes.
My lord, we submit that if these conservatory orders are not put in place, which are very critical in preserving the subject matter, pending to the court's determination of the petition, then the governor will suffer undue prejudice, my lord.
Yes.
I do not wish to restate what I've already said with regards to the organizational structures being changed in the county. I wish to save the court's time. My lord, the other issue is whether the granting of these orders is in public interest.
Yes.
My lord, we submit that it is in public interest that these conservatory orders are maintained for continuity of service in the county government of Meru, my lord.